So hello everyone and welcome to Career Launcher. So in today's class we are going to discuss about a bill that has been recently passed in the Lok Sabha and that is about Supreme Court Number of Judges Amendment Bill 2006. It has been passed in the Lok Sabha and very soon we will see it would be passed in the Raj Sabha as well. So what exactly it is? Basically if you read it, it actually means that the number of judges are being increased, most likely. Yes, that is what the name says, because number of judges, they are amending that law. It means it must be altering the number of judges in the Supreme Court, right? And if you apply the logic, of course, since our population has been increasing, etc., we will always increase the number of judges instead of decreasing it. So the common sense also says that this bill talks about increasing the number of judges in the Supreme Court of India. And yes, that common sense is correct. We will talk about this in detail. Now, 4th August article, yes, you can see why has Parliament increased the number of Supreme Court judges? So previously we have seen increase in the strength of the Supreme Court in 2019. And at that time, the Parliament had raised the strength from 31 to 34. Okay. So that's what you should be knowing about. Now, under Article 124 of the Indian Constitution, if you read Article 124 Clause 1, it gives Parliament the power to amend the Constitution, to amend the this law or to increase the number of judges in the Supreme Court of India. Okay, so for that, a law is passed to increase the number of judges. That's what you should be knowing. We'll be discussing about it in detail. Now, before actually moving on, so let us first talk about the Parliament of India. So when you read Article 79, it talks about Constitution of Parliament. So it says that the Parliament of India comprises of President of India. So it means President of India is actually a part of Parliament, and the two houses. Those two houses are House of People and Council of States. I think this is the same thing that is written, exact statement, hai na? So they are not using the word Lok Sabha and Raj Sabha. So sometimes people get confused when they read the original text of the Constitution. That, sir, where is Lok Sabha, Raj Sabha written? So this House of People is nothing but Lok Sabha. And this Council of States is nothing but Raj Sabha. So this has to be very crystal clear. So you can see it here. So Parliament of India comprises of the President as well as Council of States, that is Raj Sabha, and House of People, that is Lok Sabha. Now if you see it carefully, President is also a part of the Parliament, you know. Okay. And you know it that when a bill is initiated, it is passed in both the houses, then it goes to the President and the President finally gives the assent. Okay. Now let us move on. When we read, actually, we have done with Article 79. Now let's move on to Article 85. Because we have seen in the last few days, students were saying, sir, please discuss about the sessions of the Parliament also. So that's why I have decided to discuss the sessions of the Parliament as well. Okay. So when you read Article 85, it says the President has the power from time to time to summon each house of the Parliament. Each house means both the houses, and I mean both Lok Sabha as well as Raj Sabha, at such time and place as he thinks fit. So of course, it is the Parliament session is actually called by the President of India. But 6 months shall not intervene. Okay, first thing is President shall inform, but it, of course, it is generally done on the advice of Council of Ministers. So the Council of Ministers means the Prime Minister and the Ministers. They actually advise the President to summon actually the both the houses. Okay. So when the President summons it, actually, the Constitution only says, it does not talk about actually how many types of conventions are there, how many types of sessions are there, etc. It only says that there should not be a gap of more than 6 months between the two houses, the two sessions. Between the two sessions, the gap should not be more than 6 months. That's it written. That's it. But in practice, we have seen 3 sessions happening every year. Now, this practice is not actually taken from the Constitution of India. It is not a constitution. We have taken from convention. We are following these conventions from Britain, etc. You know these things. So we have 3 sessions of the Indian Parliament that happens every year. Though it is not written in the Constitution, Constitution only says there should be a maximum gap of 6 months between the two sessions. Between the two sessions, the maximum gap can be 6 months. Okay. So now, if you are aware, there are 3 sessions. The first session says budget session. January, February, March, April, right? Generally, it is around January, February. where actually budget is presented, the money bill, finance bill, these things are actually there. And this is considered as the longest session because you need a lot of things to pass, etc. A lot of appropriation bill, money bill, finance bill are passed. Next one is monsoon session. It happens in July, August, which is right now. Right now we are seeing this, and in this actually, this bill was passed, which we are discussing in today's class. Okay, and the next one actually is third one is called as winter session, that happens around November, December. Okay, so these are the 3 sessions that actually happens. Now, let us talk something about it. You should know some few words with regards to it. For example, what is the prorogation of House? So prorogation of House means prorogation of houses or either of the House. So basically the President summons means call the House. Okay. So for example, let's say, I'm just giving example. Let's say he called the House that from 1st July, he called the houses, both the houses, Lok Sabha and Rajya Sabha. And let's say on 10th August, the President wants, there's a proposal to prorogue. Prorogue means end the session. So who ends the session? Basically, first, let's say it is in the Lok Sabha. So Lok Sabha Speaker will adjourn it, sign die. Adjourn, sign die, it is called. Adjourn the session, sign die. Then the President will issue the prorogation order. Prorogation means you are just ending the session. So the President has the power to prorogue the session of either house, means both the houses, Lok Sabha as well as Rajya Sabha. And the President can dissolve the House of People. Here they are not writing both houses or either house, because Rajya Sabha is not dissolved. Only Lok Sabha can be dissolved, right? So dissolve the House of People, like for example, every 5 years, and before the election, it is dissolved by the President of India, right? So these are the basic things you should be knowing about. Okay, let's move on further. So basically we are talking about this bill, Supreme Court Number of Judges Amendment Bill 2026. It was of course introduced by Law Ministry. It has been passed in the Lok Sabha, initiated in 28 July and passed in 3rd August. And we will see very soon it will be passed in the Rajya Sabha. Now, so what it says, the bill seeks to replace Supreme Court Number of Judges Amendment Ordinance 2026 issued on 16th May. Now, this we will discuss actually, this is very interesting also, and we are going to discuss. So what happened was on 16th May 2026, the President of India promulgated an ordinance, Supreme Court Number of Judges Amendment Ordinance 2026. The President of India promulgated an ordinance. So promulgation means making the law, promulgated an ordinance which increased the number of judges of the Supreme Court from 34 to 38. Or you can write like this, 33 to 37 excluding CGI. You have to write it here. So both are same thing. So in general it will be 34 because earlier it was 33 plus 1 and now right now we are having 37 plus 1. So 4 new judges were added. The provision to add 4 new judges were brought by this ordinance. Now you know what is the ordinance? I'm sure you must be aware. Yes, President Draupadi Murmu promulgated the ordinance to increase the strength of the judges from 33 to 37 excluding CGI. So including CGI, by default we will say 34 to 38 if we are not writing excluding CGI, because CGI is also a judge. Okay, so either you have to write increase from 34 to 38 or you have to write 33 to 37 excluding CGI, like that. Now, what is an ordinance? Ordinance behaves like an exactly like an ordinary law of the Parliament. Why I'm using the word ordinary law? Because it is not a constitutional amendment cannot be done through ordinance or any other law. Like this is just a simple law that is being passed in the Lok Sabha, Rajya Sabha. Exactly the same power or same thing is ordinance, but it is passed by the President only when both the houses of Parliament are not in session. Basically say if at any time except when both the houses are not in session. Okay, it means, let me clarify it. It means when ordinance can be passed when both Lok Sabha and Rajya Sabha is not in the session, when Lok Sabha is in the session and Rajya Sabha is not in the session, when Lok Sabha is not in the session and Rajya Sabha is in the session. In all these cases, ordinance can be passed. But when both Lok Sabha and Rajya Sabha is in the session, ordinance cannot be passed. Okay, that's what it means. So we use the word recess for that, na, when there is a gap between the two sessions, recess. So this is actually because why it is case, because if one of the houses is in the session, you cannot pass the law, right? It needs both the houses' permission, right? So that's the idea behind this. And do not say apply the logic that sir money bill can be passed only in Lok Sabha, because I've told you ordinance is only for ordinary normal bill. So of course that's what the idea is. So basically the idea is, when both the houses are in the session, you cannot pass. When both the houses are in the session, you cannot pass ordinance. Otherwise, in any other case, you can pass. The president can pass, I would say. Or president can, the word used is promulgate. Can promulgate an ordinance under Article 123. Similar is the power with the governor, 213 in the states. However, the most interesting thing which we are going to discuss. So basically, once the ordinance is passed, now whenever a new session will come, it should be passed and shall cease to operate at the expiration of 6 weeks. When the parliament reassembles, within the 6 weeks, they are supposed to be passed. That's what the idea is. So if I ask you what is the maximum length of one ordinance, maximum time period of an ordinance, the answer would be 6 months and 6 weeks. Why? Because understand one thing. When when ordinance is passed, okay, when the next session comes, within the 6 weeks, both the houses are supposed to pass it. Otherwise, the ordinance will lapse. Okay. Now, I have told you what is the maximum gap between the two houses, between the two sessions. 6 months. So, for example, let's say winter session ended, and just the moment it ended, next day, president promulgated an ordinance. Now, maximum gap between this would be 6 months. And once actually a new session will start, within 6 weeks, they are supposed to pass. So, maximum scope of ordinance, the maximum length or tenure would be 6 months, 6 weeks. That is what you should be knowing. This is what I was clarifying. Although generally it is not like that. There is no, generally we do not have gap of 6 months between the two sessions. I have discussed that in as a convention or as a practice, there are 3 sessions. And we have discussed. Okay, so this was passed to increase the number of judges. We are talking about the ordinance that was passed in May. Now what happened was, once the ordinance was passed on the 3rd, on 16th May, on 3rd June actually, the Supreme Court recommended, the Collegium recommended 5 new judges, and of course it was approved by the government. And the president appointed 5 new judges. If you are interested in knowing how the Collegium system works, you go to the YouTube and search this. Collegium system, career launcher, law entrance. You will get a video. Okay. Now, so Supreme Court got 5 new judges, because the strength was increased to actually it was increased to 38. Strength to 37. They should not write, or they have to write 37 excluding CJ. They have to write like this. So that's what you should be knowing. So this ordinance was passed. Supreme Court number of judges amendment ordinance on 16th May. And the government side, like these are the judges that were appointed. In fact, the most interesting was Justice V. Mohanna. She was a senior advocate. And now we are having 2 women judges, Justice V.S. Mohanna and Justice B.V. Nagaratna, who is going to be the first woman CJI in 2027. And first woman to be directly elevated from bar was Justice Indu Malhotra, and she has become the second woman. Directly elevated from bar means directly a lawyer has been appointed as a judge of Supreme Court. Instead of being appointed, because general practice is lawyer is appointed as a High Court judge, then it is appointed as a Supreme Court judge. But in some cases, we have seen a Supreme Court lawyer directly appointed as a Supreme Court judge. Okay. We have seen in male judges also, we have seen some judges. But in female, we have seen second one. Justice Indu Malhotra was the first from being a Supreme Court lawyer. She was a lawyer. She was directly appointed as a Supreme Court judge. And then the second one is Justice V.S. Mohanna. So swearing in ceremony happened. And who administers the oath? The CJI administers the oath, not the president. This has to be very crystal clear. Supreme Court judge oath is administered by the CJI. But if the CJI's oath is administered by President of India, this you should be knowing it. So recommendation made by the Collegium comprising of the CJI and the 5 judges of the Supreme Court. Okay. The law minister at the cabinet rank is the law minister of India, I think is Minister of State if I'm not wrong. Please check his rank. Mr. Arjun Ram Meghwal has announced the decision that under Article 124 Clause 2, President is appointing these judges. Okay. So we are done with this. Now, this happened. So this was done when the ordinance was promulgated. But there is one caveat. This ordinance can lapse if the parliament or the comes up with a new session and within 6 weeks it is not passed. Then from this logic, this where it is, okay, this ordinance could have lapsed and it could have created a constitutional crisis in that case. This is ordinance. Now, like in the monsoon session has been recently reconstituted and they are supposed to pass it within 6 weeks in both the houses. Right now it has been passed in Lok Sabha. Imagine if it is not passed in the Raj Sabha. Imagine just for 1 second, although generally it is not blocked, these types of things are not blocked by the opposition. But imagine if it is not passed, then it will create a constitutional crisis because the ordinance will lapse and again it will go back to 34 judges. And I have just checked it on the Supreme Court website. There are currently, I think, 35 judges or something. So that will have created a constitutional crisis. But we hope that nothing of such sort will happen. So if you see it introduced in Lok Sabha and the passed in Lok Sabha, we hope that very soon it will be passed in the Raj Sabha as well. Okay. And these are the things, and increase the judges from 34 to 38. So Supreme Court, this bill amends this act. Supreme Court Number of Judges Act 1956 was passed, which talked about the number of judges. Now it is amended again. You know what is a puisne judge? Puisne judge means judge other than CJI, other than Chief Justice. So puisne judges were 33, it has increased to 37. But overall, it was 34, increased to 38. Because we have to include CJI also in that. And so since 2000, we have seen in 2019 the same thing similar happening. So in 2019 it was 30 plus 1, increased to 33 plus 1 in 2019. Then recently in 2026 we have seen 37 increased to 37 plus 1. Okay, of course the government has said that we are doing this, of course, because there are a lot of pendency of cases, etc. We need to increase the number of judges. That's what you should know. He is the Law Minister of India, Mr. Arjun Ram Meghwal. Find out what is his rank. As far as I remember, he is having Minister of State independent rank, independent charge. But please check his rank. The increase in judicial is one of the most existent viable solution, etc. It would enable Chief Justice to make more constitution bench. What is constitution bench? I'm sure you must be aware. When you read Article 145 Clause 3, minimum number of judges for interpreting the constitution should be at least 5, or actually even in Article 143. So if there is a case which requires an interpretation of the constitution, minimum 5 judges should be there. That's called as constitution bench. Okay. So of course, if the Supreme Court will have more judges, of course the Chief Justice will have more scope to make constitution benches and all. And because we have a lot of backlogs, these things. It's a very famous India Justice Report 2025 said that we have 15.9 judges out of every million. 1 million means 10 lakh. So roughly you can say 16 judges out of 10 lakh population. But ideally, Law Commission of India and many reports says that we should have 50 judges out of 10 lakh or 1 million. So we are still very far away from that. Even in the high courts, we have a lot of pendency. Even in the district judiciary, we have 25%. Even in high courts, we have 30-40% vacancies. So these things need to be filled. So what was the original strength? That is very interesting. Article 124, if you read, it says original strength. The Supreme Court of India shall consist of a Chief Justice until Parliament by law prescribe a larger number of not more than 7. It means originally in 1950 it was the Chief Justice of India plus 7 other judges. So total there were 8 judges, 7 plus 1. And it says until Parliament by law provides. It means it is the Parliament which amends this, which increase the number. For that we have made a separate law, Supreme Court Number of Judges Act 1956. And these are being amended time to time. Okay. So we had 8 judges in 1950, CJI 7 plus 1, I would say. Then in 1956, it increased to 10 plus 1, 11. In 1960, 14, 18, 26, like that, 31, 34 in 2019, and now 38. All these are including the CJI. So it has been passed in the Lok Sabha, and we hope that it will be passed in the Raj Sabha before it will be sent to the President, etc. Okay. And then it will replace the ordinance. and it will fix the sanction strength of the Supreme Court. Now let us talk something about the Supreme Court of India. It's the highest authority appellate court for the civil and criminal matter. These things. It was established on 28 January 1950 by replacing Judicial Committee of Privy Council. And it is in Tilak Marg, New Delhi. This is very important. This was asked in the exam somewhere in AILET. What is the motto of the Supreme Court of India? The answer is Yato Dharmastato Jaya, which means where there is dharma, there is victory. Or where there is righteousness, there is victory. Or we can say where there is justice, there is victory. Okay, so it has been taken from Bhagavad Gita. Sometimes these are also asked in the exam. Okay, Article 124. Mandatory retirement is 65 years. These things. It is English is the main language, not Hindi actually. Technically, it is not correct. Article 348, when you read, it says that all the proceedings in the Supreme Court and in every High Court should be in English language. Although in some High Courts, there is a provision of translation, but originally it should be in English language. Okay, so you should remember, the language is English. And the first Chief Justice of India was Justice H.J. Kania. Okay, now let us talk a little bit about the information related with High Courts. Like the oldest High Court of India, established in 1862, Calcutta High Court. Then after Bombay and Madras High Court, but oldest is Calcutta High Court. The newest one, is Andhra Pradesh High Court and Telangana. So we had a High Court, Andhra Pradesh High Court, which was there in Hyderabad. And after the splitting of Telangana and Andhra Pradesh state, that Hyderabad High Court, that Andhra Pradesh High Court had become Telangana High Court. This is the Hyderabad, the old one. And a new High Court building has been made in Andhra Pradesh High Court. So we have total 25 High Courts, although we have 28 states and 8 union territory. We have 25 High Courts in India. So Allahabad High Court is having 160 judges. This 419 is current judges, current number. And this is the vacancy. You're not supposed to remember, this is the largest High Court of India. Largest means largest number of judges. 160. Then we have Andhra Pradesh High Court in Amravati. Allahabad High Court is in Prayagraj and it has a bench in Lucknow also. Bombay High Court is in Mumbai and it has a bench in Nagpur, Panji, Kolhapur, etc. It has jurisdiction, it has multiple jurisdiction. Yes, you have to see. Maharashtra, Dadar and Nagar Haveli, Daman and Diu is one union territory now. And Goa. Calcutta High Court has jurisdiction of Andaman, Nicobar and West Bengal. They have actually main benches in Kolkata and other benches in Port Blair and Jalpaiguri also. Chhattisgarh High Court, it is principal seat is in Bilaspur, not in the capital. This has to be very crystal clear. Delhi High Court, union territory having Delhi. Guwahati High Court, this is a High Court with maximum number of jurisdiction. High Court with maximum number of jurisdiction. Arunachal Pradesh, Assam, Mizoram, Nagaland, 4 states. And in Guwahati, and this is the benches are in different places. Gujarat High Court is in capital. Himachal High Court is in capital state. Jammu Kashmir and Ladakh High Court, it includes Jammu Kashmir and Ladakh union territory. Jharkhand High Court, Ranchi. These are simple. Karnataka High Court, Bangalore, etc. Kerala High Court has Kerala as well as Lakshadweep jurisdiction. Madhya Pradesh High Court is not in the capital, Jabalpur. Even Kerala High Court is not in the capital, Kochi. Are you able to see? Madras High Court is in Chennai, you know this. They have a bench in Madurai also. Madhya Pradesh High Court main is Jabalpur. There are other benches like Gwalior and Indore also. Manipur High Court is there, Meghalaya, Odisha, Patna High Court is there. These are simple, straightforward. Punjab and Haryana High Court, it includes Punjab, Haryana and Chandigarh Union Territory. In Chandigarh. Rajasthan High Court, again, it is not in the capital, Jodhpur. It has a bench, another bench in Jaipur, but main parent High Court is in Jodhpur. Okay, Sikkim, Telangana, you can see. And Uttarakhand, again, its High Court is not in the capital, it is in Nainital, not in Dehradun. Okay, these things you should be knowing. So these are the states, High Court states in Union Territory. This we have attached Andaman Nicobar, Port Blair mein. It's a part of Calcutta High Court. Itanagar mein, Guwahati High Court, etc. We have already discussed it. Andhra Pradesh High Court is in Amravati. This is the new proposed capital. So you can see it. We have already discussed these things. So just read it once. So this is all about today's class. Please subscribe to our channel, press the like button, share this video. Thank you everyone. Thanks for watching. Have a nice day.